Okay, this is part 2 of the Bill of Rights lectures. So, officers conducting the search must announce that they are law enforcement officers, they possess a warrant, and they are there to execute the warrant. Then they're required to wait 15 to 20 seconds before entering in order for the occupant to respond. The exception to this is if the officers believe that evidence will be destroyed or that notification would pose a threat to the officers, in which case the officers do not need to wait and they may enter using force if necessary. Also, if in the course of conducting a legal search, the officers discover an illegal substance or object or evidence of a crime not covered in the warrant, they may legally collect the evidence under the plain view exception without obtaining a warrant. Before the case of Schimmel v. California in 1969, officers could legally search without a warrant the entire presence surrounding the arrest. This type of search is called search incident to arrest. Now, they're only legally able to search the area within the control of the suspect. Generally, this is the area within which the suspect could access a weapon. So moving on to the seizure part of the fourth, there are two types of arrest: physical custody, which I'm sure you all know about, and constructive custody, which is when the accused peacefully accompanies the police. Most arrests are made without a warrant. However, if the officer has to enter private premises, then a warrant is usually issued. Arrest warrants are only issued if a violation of the law has occurred and if the person to be arrested committed the violation. Officers can, however, enter a private home to make a warrantless arrest if the offense is serious and there's destruction of evidence likely. The officers must be in hot pursuit, however. Okay, here we go. The Supreme Court has continued to refine the scope of warrantless searches, except when it comes to arresting suspects who are in a car. Now officers are able to search the whole car and trunk, including any packages either open or unopened, if they have probable cause to believe that there is evidence or contraband. This includes any passenger's belongings. The key issue here is that the police must have probable cause. For example, if the police stop someone for a routine registration check, unless they actually see drugs or drug paraphernalia, they cannot conduct a search. Another situation where warrantless searches are permissible is when there are exigent circumstances. Police are permitted to search in emergency situations or if the suspect consents to a search. These situations include a need to prevent the imminent destruction of evidence, a need to prevent harm to individuals, or the hot pursuit of suspects. In another well-known case, Georgia v. Randolph, in 2006 involved co-residents of a home. This one's kind of interesting. The wife was concerned about her husband's use of cocaine. So when the police arrived, she told them the cocaine was in the bedroom and she consented to the search. However, the husband was present and he did not give his consent. That's a surprise. The police ignored him, found the cocaine, and arrested him. Later, the Supreme Court said that cocaine could not be entered into evidence because the husband had a reasonable right to privacy in his home. Let's move on to standards of proof that are necessary for legal search and seizures. The first one is gut feeling. This is, let's see, somehow I think I've gotten behind on my slides. Here we go. Mere suspicion. This is kind of like a gut feeling. Then we have reasonable suspicion. And with this one, the law enforcement officer can stop and frisk. For reasonable suspicion, the officer must be able to articulate the reason for the suspicion that a crime has been committed. Next, we have probable cause. They can search or arrest in this case. There's a fine line between reasonable suspicion and probable cause, and usually this is decided in the courts. Next, we have preponderance of evidence. There must be enough evidence to overcome doubt or speculation. This is the necessary standard of proof for civil suits. This standard of proof can be used in some criminal proceedings, and it requires the state to show that the right to counsel has been waived knowingly and intelligently. Then next we have, clear and convincing evidence. This one is required in some civil cases, and in federal courts, it's the level of proof necessary for a defendant to make a successful claim of insanity. And finally, we have beyond a reasonable doubt. This is the standard of proof necessary to find a defendant guilty in a criminal trial. And finally, we have the exclusionary rule. And the Patriot Act, but I'm not going to cover the Patriot Act in this lecture. The exclusionary rule says that illegally seized evidence cannot be used in federal trials. In 1961, this rule was extended to state trials. And there are three main purposes for this rule. And to protect individual rights from police misconduct, to prevent police misconduct, and to maintain judicial integrity. This is another case where public outcry affected legal matters. Public sentiment was against criminals who got off on technicalities. So in 1984, the Berger Court decided two cases that weakened the exclusionary rule. U.S. versus Leon and Massachusetts v. Shepard, the court ruled that if the police acted in good faith when they requested a warrant, the evidence they collected could be used in court, even if the warrant is illegal or defective. An example of this would be if the judge who issued the warrant used the wrong form. The second case was Nix v. William, which established the inevitable discovery exception. In this case, the police tricked Nix into leading them to the hidden body of his murder victim. The court ruled that if the prosecution can show by a preponderance of evidence that the information ultimately or inevitably would have been discovered by lawful means, it can be used in trial. Okay, on to the third